Ms. Graham.
Thank you. Ms. Caffrey, I'd like to move on to another issue. And this relates to the time things take over which decisions are made by officers and actions are taken. So if we can look at a scenario where, following on from what we've been discussing yesterday and today, that the first officers arrive at the scene at 7:20 and 23 seconds to be precise.
Yes.
And those are the first officers at the scene at that time, and they're looking for a subject in light of the grade 1 calls about the knife incident. By 7:21 and 19 seconds, now on my calculation that's about 56 seconds in total, but I'm very happy to be corrected on that. But the time is 7:21 and 19 seconds. That is at the time an officer has pressed an emergency button, and by that stage the man is on the ground. During that period of time, CS and PAVA have been discharged 6 times. The man has been struck to the head and body multiple times with a baton and has been shoulder charged to the ground. Now, bearing in mind your evidence about the actions of a reasonable officer or reasonable officers, and bearing in mind the minimum force principle and the attempts by reasonable officers to observe preclusion, do you have any comments about the duration at which those events took place, the period of time over which those events took place?
My initial feelings when looking at how many uses of force were used in that period of time was that was a lot of use of force within that period of time, especially when you start thinking about some of the timing with the CS and PAVAs, because the average, if the CS is full, there should be 6 seconds of use in a can of CS. And if the PAVA is full to empty, is about 10 seconds of use in PAVA. So thinking about it, if they're used, that's time as well. And then everything just seemed to be a lot in a small period of time. Now, that's not to say it wasn't necessary, but it's a lot in that time. And all the time thinking about preclusion, the amount then of tactical communication for that to occur as well. Tactical communication can be a lengthy process, or it can be a short process, but it's trying to use the lower levels before the use of force.
And are there any limits on the time that reasonable officers can take to communicate, build rapport with a person?
There's no time limit at all.
So again, depends on the circumstances.
Yes, and it can be beneficial to in some way stretch out the communications, especially if you're aware of other resources attending and specialist resources. The more that you can delay having to approach the person and delay it through communication, then that can be beneficial.
And was that what you were saying yesterday about buying time?
Buying time.
For other resources, other units, other specialist resources to attend the scene?
Yes, and it gives you thinking time. You know, it's buying time for resources to get there, but it's buying you time to think and start thinking about what checklists, what options do I have?
And to feed that back to ACR?
Yes.
And perhaps if you're buying time and able to buy time, that gives time for those resources to arrive and gives you more options if you're a reasonable officer.
Yes.
Thank you. Now, there may be some comment that although we're talking about hypothetical scenarios today, that perhaps it's easy for us to sit in the calm of an inquiry hearing. Some of us may feel calmer than others. But that fails to recognise the reality on the ground. And, events can escalate very quickly. They can deteriorate very, very quickly.
Yes.
What have you had regard to that reality or possible reality in your evidence today?
Yeah, definitely. I mean, another example I can think of is I was on patrol as the sergeant with a male constable. He had lengthy service. He was taller than I was. We went to what we thought we were going to arrest a person in relation to breach of bail. We knew the particular male in question, and usually he was of no high risk. We knew where he was living, so the male officer went to the front door for knocking on, and I went round to the rear door just in case he tried to slip out the back. And based on previous knowledge, I was thinking about, the NDM and thinking about the risk. I was quite happy as a young fit woman at that point that there was no high risk to me if he came out at the back door. So then I was next aware of a commotion within the property of just loud bang, 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 bang coming closer. And next thing the back door opened and this male officer and the subject came hurtling out of the door. And it looked like this young man that we'd gone to arrest. He was smaller than I was, but the officer who was in excess of 6 foot, the impression I got was that he had the officer off his feet. I know in reality he wasn't off his feet, but it was as though he'd just picked him up with this like superhuman strength. And that then, I mean, it was a shock to me because it was outside of what we had assumed would occur. Seeing how he was handling the male officer, I instantly then got my baton out and racked it. And at that point, this one was the PR24 baton, which is the one with the side handle bit, not the asp. The asp replaced that one. So I racked the baton as the young man just seemed to throw the male officer across this backyard. Then he turned to me and he just stood there and made himself, he just appeared as though he suddenly went 6 foot tall and just pumped up. And I had my hands out and I just said, "Keep away," or words to that effect. And he just started slowly, like in slow motion, moving towards me and growling, in effect. I knew the male officer was in a heap over in the corner area, and I swung the baton as I said, "Get back," and I swung across at his leg, which was the primary target area. As the baton came back up and he's still just slowly walking towards me, I said again about "get back," and hit the thigh on his right leg. And at that point I looked at the baton because I thought, has it racked? I thought it had maybe failed to open and I was just swinging into air, but it hadn't. So at this point his arms were up like this and I hit across at what would be his left arm, and again nothing happened. And then he just seemed to do I don't know whether it was a smirk or what, but his face just changed, and by this point he's sort of this distance. But it was just a really slow but a very intimidating move towards me. And at this point I was still thinking where next to hit, and I just thought I don't want to hit the head because I was thinking Reddy's dead. But the other area then that I struck into the chest, because although the English version was the red, amber, green colour, so the sternum was red, around the sternum was the amber. So I hit across the chest as hard as I could, thinking now I don't know what else. And at that point he just seemed to drop to the floor. And again at that point 2 other officers came running in because as this had gone on, I'd called up for urgent assistance as the 2 of them came out. So the other 2 officers then arrived, and my other colleague who had been thrown across the yard, he was then there, and the 4 of us managed to quickly get him under control. But then one of the first things I asked for was an ambulance to the location, because it was out of character anyway, but it was specifically out of character for him. We then ended up going to hospital with him with the ambulance, And then once he was cleared from hospital, we took him to custody. And then the healthcare professional, the FME, came to custody to examine him as well because of the use of force that was used against him. And he was bruised across the chest and the arms and the legs from the baton strikes. So I knew the strikes had hit. But it turned out, because then afterwards he apologised to me for his behaviour and said he couldn't remember anything. And I had been custody sergeant for him at times as well. So we had that sort of professional relationship. But he couldn't remember the actual event at the house.
How long did that sequence of events take at the scene, not as you went to the hospital?
Yeah, very quick, really, because even though I'm saying he walked towards me slowly, it was like time slows down in your mind as you're seeing things happen, because you're still looking at these checklists and thinking, you know, is this really happening? What do I do now? So I think my mind was working quicker than reality was. It was a very quick event.
Could you give us an estimate of the duration?
You may be talking about 10 seconds from them flying out of the door to him hitting the floor. We're probably only talking about 10, 20 seconds tops.
And in that experience, were you observing the principle of preclusion?
Yes, thinking that there was only the fact that he had thrown this male officer like he did. I just knew straight away with my demographics, if he could pick this officer up, he could pick me up, no problem. If he was able to throw this officer, he could throw me, no problem. So then thinking about the risk, then the fact he was just purposefully then just staring straight at me and coming for me, could have easily gone by to the gate, but he was just coming straight for me. So thinking about then going straight to defensive tactics, I was still saying get back, but then I drew the baton ready in case he didn't.
So you were demonstrating with your body language and communicating what
Yes.
you wanted, and also you mentioned you were giving feedback, or you were on your radio, I should say.
That was as the first came out. I then called up for urgent backup to the location. I don't remember the exact message. I do remember saying urgent backup to the location.
And you've also mentioned you were pressing
Yes,
your
the
radio
radio.
for the ambulance.
And then, yes,
At the end.
when we then ended up on the floor, one of the first things I did was call for ambulance required at the scene.
And in those circumstances, were you bearing in mind minimum force? You've talked about the different areas you tried.
Yes, because I was thinking that I tried. I mean, I thought I was only at the back door as an overlap. I wasn't actually expecting anyone to come out the back door. But then I tried the hands up, the backing off, because I think if I slightly moved back, but there was clear access. He could have gone out of the gate of the yard as well, but he didn't opt to go that way, so I wasn't blocking the exit there.
And you went for the legs first, the arms next, but not the head.
Not the head. No, I've never struck anyone in the head. Only because I keep thinking back to basic training all the time about head is red is dead.
Right. So is it fair to say that in considering these circumstances, the hypothetical scenarios I've put to you, you have borne in mind that reasonable officers could be in a situation where events occur very quickly?
Yes.
And does that minimise or diminish any of the evidence you've given today?
No.
Can I ask you take you back to the national decision-making model and the risk assessment? Would a reasonable officer consider that a person's race was a relevant factor in assessing that risk assessment?
No.
Why is that?
Because race shouldn't bear an issue on it at all.
Right. If there is intelligence, the police are notified of a threat level at the time, and would the existence of that threat level or intelligence about say, a terrorist threat, be something that could be factored by a reasonable officer into their national decision-making model?
No, because then you would just be putting a blanket, a blanket on something, rather than it being intelligence-led, as in this particular person or this particular group of people names are. So then you can't just say because of the colour or the sex or the gender of the person that would be a blanket application.
If there's information at the time that there is a severe threat level for police officers, is that something that reasonable officers would consider when they're processing their NDM risk assessment?
They may consider the raised level, but then it would be wrong to apply that just to one group of people without any specific intelligence about that.
And what would a reasonable officer be looking for to perhaps provide more of a link between the intelligence or the threat level information they had with a particular incident they were attending?
So you're particularly meaning the terrorism side? Well, if there was an indication of terrorism because of the serious national threat of terrorism, any indication of potential link to terrorism, that should be the command and control system all over that. And there wouldn't then be directing officers, unarmed officers, straight into that. And one of the things all forces will have available are plans in relation to different levels of terrorism threat.
So if there is a genuine terrorism threat in relation to a particular incident, would a reasonable officer be right in thinking that would be information shared by ACR?
Definitely, because then you would need instantly a strategic lead on this, and the likes of the counter-terrorism security advisors, the officers who were involved in the terrorism strand would be all over this as principal partners.
In the absence of any of that, would a reasonable officer be able to assume that it wasn't a terrorist incident?
Yes, because you'd assume that the first filter of risk assessment and dynamic risk has been conducted by the ACR, and that they've now decided it's not terrorism, and which is why you're getting it. It shouldn't come out of ACR with any concept that it's still terrorism. So that's not to say it wouldn't be, but it shouldn't be coming out of the ACR if there's any indication that it's linked to terrorism.
Thank you. From your experience in training officers, I'm interested, is there any training that you know of, or indeed that you have delivered, that would assist officers in minimising the risk of them factoring racial stereotypes into their risk assessment?
Well, if we look back over the history of policing and like diversity training, and I attended the Home Office diversity train the trainer course, which was 6 weeks in, I think it was 1996 I attended, and it was 6 weeks down in Bedfordshire at a place called Turvey. It was one of the Home Office training sites. Now that then permitted me to deliver any kind of diversity training within any of the Home Office establishments. Now, at that point, because I had already, in order to do that, I also needed, prior to that, the Home Office law course. So that was a 13-week course, and then that was 6 weeks on top of that. So you build these things up as different modules. I then went back to Cumbria, and I designed and delivered some of the rollout of the initial they called it community and race relations training at that point. I delivered during the first year of a rollout. Now the initial plan was after that all training courses would be incorporating all the relevant strands of diversity. So then years later, when I was then designing and delivering the custody training, for example, I would then ensure that as much as possible, it was as diverse as possible, and we were looking at all issues which would include race, sex, sexuality and disabilities as much as possible throughout the whole thing.
So was there a specific training that you're aware of from your own experience that assists officers in avoiding or guarding against any racial bias?
No, not specifically. It would be very much down to each force to design their own, looking at performance needs analysis and training needs analysis. It would be down to each force to establish at what level they wanted their staff trained. There was no one national standard that said every police officer has to have this. So you would find differences between each force in relation to whether the focus, for example, was mostly internal in relation to race relations or equality and diversity, or whether it was external or a mix.
And as I understand, we'll hear more evidence about training in the future. But can I ask you one final thing? In relation to, we've heard about annual accreditation or recertification of officers.
Yes.
And I think at one point I had said officers in Scotland do 1 day. I think that was incorrect. It's now 2 days.
Yes.
Every year. We've heard some suggestions that equality and diversity is taken into account when they're doing use of force training or OST training. What's your views on that?
Well, it's supposed to be, but then it's down to each individual trainer then and what emphasis they give on it, because they have their training objectives to meet, but it's mostly around, can the delegate do this technique, that technique, rather than have you included an example about this and about that. So yeah, the training's more aimed at performance task rather than the process within it.
Thank you. Could you allow me one moment,
Yes.
please? Could I ask you about your awareness, if you have an awareness of deaths of black men in custody, perhaps after restraint, and whether that's something that's covered in OST, officer safety training?
Yeah. The main case that was significant for me was the death of Christopher Alder, which it was released, the inquiry into it was released in 2006 by the Independent Police Complaints Commission in conjunction with the launch of the Safer Detention guidance. So that one became quite a national, well-used case study throughout custody training, but it was custody training rather than officer safety training. But then in custody training, you're also teaching the theory of officer safety training and how it fits. The downside is the only people who go on the custody track are either the custody officers or the civilian detention officers, not all your mainstream constables. But Mr. Alder, he had been the victim of an assault with a scenario of the one punch outside a nightclub. Because of his behaviour then, he was considered to be disorderly. He'd been taken to hospital. Again, his behaviour was considered to be disorderly rather than the byproduct of a head injury. He was then released from hospital. The officers then took him to custody on the grounds of a breach of the peace. By the time they got to the police custody, he was handcuffed to the rear but unconscious, but they believed he was faking it and lay him face down in the booking in area at the custody unit. And it was some sort of 12 minutes later before staff realised that he wasn't actually fully conscious. The noises they thought was breathing was actually signs of it was not breathing normal and believed to be heading into cardiac arrest. And then unfortunately he died. So that incident was used by a lot of custody training in relation to the emphasis of the use of force, the first aid, the head injuries, looking at the racial aspects as well, because that was brought up in the investigation as well, about the racial aspects, the first aid aspects. It sort of held a lot of the topics which then Safer Custody was covering.
Again, we'll probably hear more about this at a later hearing, but does this also tie back to what you said earlier today about the distinction between breathing and not breathing and normal breathing not normal breathing?
Yes.
And the current view, or the view in 2015, would have been whether the breathing was normal or not normal.
Yes, because throughout that footage you can hear him breathing on the custody CCTV recording, but it's not normal. It was described as being something between a snore and a groan.
Right.
But it wasn't normal breathing.
And that was in the situation where the man had a head injury.
Yes, but officers hadn't appreciated that there was a head injury.
Right. Thank you very much, Ms. Caffrey. Thank you very much.
Thank you. I'm going to adjourn to consult with my assessors at this point. Now, are there any Rule 9 applications? Mr. Jackson and the Dean. Ms. Caffrey, I wonder if you would withdraw to the witness room while I hear some submissions.
Yes.
Yes, excuse me, Dean of Faculty.
My Lord, Your Lordship will, I hope, have seen that a fairly lengthy Rule 9 application was submitted timelessly on behalf of those that I represent. That was responded to by the Solicitor to the Inquiry, indicating that the number of questions that had been raised by ourselves and by others were such that Counsel to the Inquiry didn't feel it was going to be possible to put all of the matters to the witness herself, and so it has transpired. My Lord, there are a number of issues in the Rule 9 application that have fallen away, but there remain various issues that I would like to explore with this witness. And in addition to that, given her commentary on Mr. Graves' evidence today, I would like to explore the extent to which she agrees with certain other aspects of Mr. Graves' evidence that we haven't heard about. I'm not sure, my Lord, if Your Lordship wants to hear from me on all of the paragraphs. I can certainly outline the various paragraphs that remain extant, but that will take some time in itself, or Your Lordship might just trust that I will exercise all due economy in asking the questions of this witness.
I mean, the Rule 9 is designed to apply to lines of questioning rather than a whole series of specific questions. And I would welcome a submission from you as to what lines of questioning you consider have not been covered.
So the first of those, my Lord, relates to the qualifications of the witness to offer the opinion evidence that she does in a number of different aspects. And that might be said to be the first 28 paragraphs in the Rule 9, although, as I say, an awful lot of those have fallen away.
Well, that's my point. I mean, I wonder to what extent that issue, now that she's given evidence, is one for submission as to what weight I can place on her evidence.
Well, we have considered that, my Lord. The view I took, and that I continue to take, is it would be quite unfair for me to attack the credentials of this witness in a submission without putting to her the basis upon which I challenge her expertise. And my Lord, I don't want to be unfair, and I'm sure the Chair doesn't want to be unfair either. So in my submission, that wouldn't be appropriate. The second aspect, my Lord, really relates to the question of waiting for the dog unit. The third relates to ABD, or excited delirium, and the extent to which...
Just before you go into that,
I'm sorry.
In relation to waiting for the dog unit, her report was compiled on the basis of the evidence available to her at the 31st of October.
Yes.
And then there's subsequent evidence which clarifies the amount of time that will be available for the dog unit to come, which she's now taken account of.
Well, the evidence available to the witness would have included the evidence of Mr. Stewart, which said it would have taken 25 minutes. Which
yes,
does
precisely.
But this witness is, thus far, has proceeded on the basis of 10 to 15 minutes. So it would be appropriate to explore with her the extent to which it would be appropriate to wait for the dog unit. As I understand it, she's still saying it would be appropriate to wait for the dog unit. Now, that is a view that requires to be explored further in my submission.
Well, I can't precisely remember what she said, but my impression was that she had taken account of a longer time. But I could have a look at that.
Well, it certainly, I mean, we can get the precise aspects. Certainly, my impression from the evidence given by her yesterday and today is that she still holds to the view it would have been appropriate to wait for a dog unit.
Oh yes, that may be the case, but for a longer time.
Yeah, and that is something that requires to be explored in my submission. The third is relates to what the witness has said about ABD or excited delirium, and that is in part relates to her own expertise, but also in part relates to the actual available evidence regarding what the officers saw or should have seen at the time. And then we move, my Lord, to the question of containment and the extent to which, because that is again, I mean, that's closely allied to the dog unit point, the extent to which containment was feasible. It's obviously this witness's view that containment was feasible. That is not something that is shared, a view that is shared, and again requires to be explored. And then leading from that, we then have...
So,
I'm sorry, Lord.
What questions does containment... What questions relate to containment? Sorry.
So containment, that begins, my Lord, with... It's basically paragraph 79 onwards through to 89. And then moving on from that, we have the assessment of, first of all, the approach to Mr. Bio. Secondly,
Sorry, can you just expand on that a little bit, the approach to Mr. Murray?
yep, so this is paragraph 83. Through to 88. And then we have the deployment of CS spray or PAVA, that's 91 onwards. Again, a lot of this has fallen away. So for example, 97, 98, 99 are all gone. But again, it is appropriate that we explore that aspect of the witness evidence. And then we have the reaction to Mr. Bio chasing and striking PC short. That's 100 to 102. And then a few questions on the restraint itself, primarily 119 and 120. I don't intend to put any of the miscellaneous points at the end, so that's 132 onwards. But I would intend to wrap things up under reference to what Mr. Graves has said, and to see to what extent she agrees or disagrees with Mr. Graves. We've had a lot of agreement with Mr. Graves today, but not necessarily with the points in which the inquiry will be most interested.
Well, I departed from the ordinary arrangements for Rule 9, as you say, because of the scale of the applications, written applications. And in further pursuit of that exercise, I suggest that when I rise, after hearing from Mr. Jackson, you and Ms. Graham should sit down and go through this application and identify precisely what the areas are that you require to you require to apply to me to allow examination. So if you can return to your seat, Dean, I'll hear from Mr. Jackson now, please. Yes, Mr. Jackson.
Like the Dean of Faculty, we have lodged a very lengthy Rule 9 application, and like him, much of it has been dealt with, and I had anticipated that when he had finished, more of it would have been dealt with, and leaving me with less, and of course, that remains to be seen. I can direct you to the paragraphs in my Rule 9 that I'm particularly interested in, which are broadly speaking from 52 and then from 66 to 86. These tend to deal with the situations involving P.C. Tomlinson and P.C. Smith, and are all to do with what I might say are criticisms of those two officers in the report by the witness and in her evidence. What I thought might be better, subject to you of course, was I would cover these rather than doing them individually, but I think it would receive the same result. What I want to do is to put to the witness what has been said by Officer Tomlinson in his evidence about the matters she is critical of, to see if she would comment on that in the light of what his evidence actually was. And I would also want to do the same as far as Officer Smith is concerned. That seemed to me to be better than going through, as it were, the individual paragraphs, but by simply, and reasonably quickly I hope, putting that evidence that's been given by the officers to this witness, that would in effect cover all the individual things that I've raised in the Rule 9. Now, I don't know if that makes sense or not.
Just before I turn to that, you made reference to paragraph 52. That relates to the practicality of diagnosing. Oh no, I'm sorry, I'm looking at Mr. Ledeen's. Yes, let me just get your Rule 9 application out. Yes, 52. And is it just 52 or is it after 52? Apart from the second tranche that you mentioned.
No, I just said 52 and then I went to 66.
Yes.
Could I just add this? Like the Dean, it seemed to me to be fairness in some ways to the witness to be able to put this sort of material that I was intending to put to her for her comments. You may, Chair, say to me, well, a lot of these things could be done just in submissions, and I get that. I do understand that, and like the Dean, I've given some thought to that. But I was left with the view, which I think he had too, that there is fairness to a witness also involved. I know these are not normal proceedings, but in any proceedings there is fairness to a witness in evaluating their evidence to put the sort of things that we were suggesting, albeit they could be made in submissions without putting them to the witness, I suppose. But fairness perhaps suggested that we should put these things to the witness. I may say I've already discussed with Ms Graham what I intend to do in general terms. What I'm saying to you as how I wanted to approach it in general terms rather than the individual paragraphs. I have already indicated that to Ms Graham at the luncheon adjournment.
Well, what I'll do is I'll consider your application, Mr Jackson, while the Dean and Ms Graham spend some time on his,
Okay.
and hopefully come to a decision in due course.
And as I should add again, I think I've said this, of course, to some degree, I was anticipating that what the Dean did might affect what I would then be asking to do.
I can see that. Thank you. Well, we're adjourned.